Resume recording. All right, Miss Martha, tell us a little bit about yourself, and then I will do a screen share and we'll walk through our slides. Is that cool? You're on mute, Miss Martha. There you are.
That's cool. One of the things I like to share, a little personal thing about myself, is I wanted to be an attorney since I was 11. I didn't know any attorneys, but there was just a strong desire. And so public speaking and debate in high school fueled my interests. And then I went to UCLA, so I have a bachelor's at UCLA, and then I went to Loyola Law School. And I like to think that I am approachable. Most people have told me that I'm very approachable, so call with your questions. We don't charge $1 million for a question. So today I'd like to talk to you about wills and trusts, and I want to thank you, Mr. Soto, for that opportunity.
For sure. Absolutely. So let me share my screen. And we'll go through, and you're going to cue me up, right, Miss Martha?
I am.
And we'll work through this. Hopefully you can see my screen that says wills and trusts, and I'm going to present. And how does that look?
Well, it looks like an Excel sheet with a bunch of things on it.
Should not look like that. Stop share.
Okay. It looked like an Excel sheet with a lot of names on it.
Should share screen too. Share. Now does it say wills and trusts?
Yes.
If you're in the chat, you can give me a little thumbs up in the chat that tells me you see wills and trusts. And now we should say it big across your whole screen.
Yes, it does.
All right. Boom. So wills versus trusts. Two biggest questions on wills and trusts. Why don't you tell us about that?
Yes, I put will versus trust because, you know, in a lot of litigation, we have the plaintiff versus the defendant. So I thought it would be like a cool, catchy title. So who will make the financial decisions is a very important question after you die, and how will assets be distributed? We can go on to the next slide. So here are some assets we might have. We might have a family home, or we might have several properties, as well as we might have several bank accounts, stocks, investments, some type of money or cash as one of our assets. Next one.
Would personal property be considered in that? I own a motorcycle or a car or an RV. Is that part of assets?
Yes, but those are usually transferred without having to go to court.
Oh, okay, cool. So what is a will?
Yeah, so what is a will? So many of you may not know the difference between a will and trust, or you may know the basics. So I'm going to try to give you like some tips also that maybe people don't know. So one of the things that it's a statistic is 42% of the people in the state of California have trust, but that leaves a huge disparity for those people who own real property and don't have trust. And Bailey and Romero, which is our new gig, our new law firm is called Bailey and Romero. My partner is a former Superior Court judge, and he ran for Attorney General in 2018. We don't believe that if you have real property, you need a will. But what is a will? So a last will and testament is a legal instrument that allows you to distribute the property after your death to people and or organizations of your choosing. And it has to be witnessed by two people who are not family members or close people from your family. We usually try to get neighbors, or sometimes we get our staff, but you have to it has to be witnessed in California.
By witness, does that mean notarized?
No, it's
just signed?
Yeah, witnessed by two competent people who saw you sign it. And basically what they're doing is attesting that, you know, that you have drafted this, that you have written this, and that you are, you know, of your own sound mind. So that's one of the things you have to put in the last will and testament.
Gotcha. Sorry, the screen. There it is. So I've got an uncle in New York, and he swears his will was fine, but his girlfriend signed it and his son. that's New York versus here. But after many, many years of telling him to talk to a trust attorney, he learned that that's not good to have your girlfriend and your son sign your will. So it's best if it's not a family member. Is that correct?
Yes, because what they're going to say is that, or someone could say is that that's influence or undue influence, or the family member is going to just say, oh, you were fine, but you were not fine, or whatever.
Yeah.
Gotcha.
Okay, cool. Awesome. Legal instrument, an executive.
Like I said, it's a legal instrument, and it nominates an executor, or if it's a woman, an executrix, to carry out the wishes of the deceased and distribute the assets.
That's what the will does.
Will does.
Okay.
We can go to the next slide. A will goes through the probate process, but
so even if I have a will, and I draw this up right here, can you see me? And I write, I want Martha to have all my stuff. Still has to go to probate?
Yes. In fact,
even though I really want you, I pinky promise that I want Martha to have all my stuff. Is that still going to probate?
Yes. In fact, if you don't have a will, it goes to probate. And if you have a will, it goes to probate.
Okay. I think that's a big misconception, right? I'm kind of joking, but I feel like a lot of, especially with my own family, right? I'm Puerto Rican. I've got a big, large Hispanic family, and so they all seem to think that if I have this, I'm covered, and it's a big misconception for people out there. So that's why I was kind of hammering it and joking with it, in that people think that it's going to avoid probate, but it doesn't.
No, it doesn't avoid probate. We're not there yet. And
sorry.
And not only does it not avoid probate, but if you have no will. So I have a current case where the mother was 105. She just died. She only had one heir, but there was no will or a trust or anything, any consideration of anything about what was going to happen to her affairs after her death. So we now have to go to probate. And what is the probate process, you might ask? So it goes through, like I said, the probate process, but that is a court supervised process to carry out the distribution of assets. And the executor is someone that we name. It could be a family member, like a witness. It could be a close friend. It could be someone that you trust, and the executor would gather the deceased assets, like go to the bank, sell the property, figure out what they need to do with regards to the will. They're supposed to carry out the terms of the will. Now, usually things like life insurance, bank accounts, stocks, mutual funds, all those kind of things, those are usually done by a beneficiary. But a lot of people don't know that, so they don't elect their beneficiaries. That's another thing that they should probably do.
Got it. I don't know if you have a slide in there, but the probate process, how long does it take, and how has COVID impacted this awesomeness?
Well, one of the things pre-COVID is that the court, so the Los Angeles Superior Court is the largest court in the world because we have several outlying courts. And there are over 850 judges in all of the whole LA County. And so many people from other countries, or maybe officials from other countries, come and look at the LA County Court because we are the largest court in the whole world. So what LA County has done in the last few years is they brought all the probates to downtown. So you can no longer file a probate in Long Beach, let's say if your property's in Long Beach, or any of the outlying courts. Now that put a big, obviously, stress on the courts and the court's dockets, because there's only so many probate courts downtown. So for a long time, there was a big backlog, and there still may be, but they had to go through all of the cases that were transferred. So they just decided someday, I don't know what that date was, that all the cases from all the outlying courts were going to come to LA. So that happened. So there could be a backlog of that. But second of all, Joe, it can take a really long time in court because pre-COVID, usually 60 to 90 days, if you filed a petition for probate and you asked somebody to be the administrator, which is the same thing as the executor, people get all confused because it could be the representative, the administrator, or the executor or executrix. They all mean the same thing.
Okay.
But usually pre-COVID, you would get a hearing to get letters, which people don't know what letters are, but letters of testamentary are the authority by which the executor or the executrix or whoever's going to administer the will, that is a paper that's their authority to go to the bank and everything. So pre-COVID, it used to be 60 to 90 days. And often you don't necessarily have to go to court because probate is really the only area of law that has what we call probate attorneys. Now they background and they are reviewing all of the documents to, just cross off, is the executor named? Is the value of the house, on there? You're just going through like a checklist of all.
Gotcha. I got a couple of little questions on here.
Okay.
One from Daryl, and I encourage you guys, if you have questions, fire them off. It makes it a lot more entertaining when we can answer questions versus listening to us talk. I mean, I think Martha and I are awesome, but we can get pretty, just hard to listen to. But Daryl had a question saying, can you have a will and trust active on the same issue? So can a person have a will and a trust? Can you have a will and a trust active, I guess, is Daryl's question, on the same issue or person? I think the answer is yes, because you could have a trust and a will, right? A pour-over will or something like that.
That's a different thing. That's unique to trust. So could you fill in a trust? I guess you could, but you wouldn't want to, because why would you want to go to probate court? And again, we don't recommend that anyone who has real property have a will. We recommend they have a trust, and you'll see why when we get to trust.
Gotcha.
Yes, you could, but they would, they're totally two different processes. So I don't think you would.
There wouldn't be a need for a will if you have a trust.
Correct.
Okay. And then Laura had a question here. What's the difference between executor and beneficiary? Good question, Ms. Laura.
So the beneficiaries are usually the heirs that will inherit the assets. But a beneficiary can also be an executor. I have a strange case right now where she went to the bank to just, do those beneficiaries, and they told her she could not be a beneficiary, and she's the granddaughter. They're going to name her as the, executor or administrator of their will. And I told them the bank was crazy because often the people who are those people that you trust are
the beneficiary.
Yeah.
So the executor is the decision maker, right? And the beneficiary is the heir.
Right.
Okay. Gotcha. Cool. Good questions, everybody.
So I want to continue on with saying it can take a very long time in court. And like I said, we have these probate attorneys that go through this checklist. Now, they post what's called probate notes, and they only usually post those when you go on to the summary of the case, just maybe 1 or 2 days prior to the case. So you may not have to show up to court if they say it's RFA, which means it's recommended for approval. If there are problems, they will say what the problems are with the documents. Then you can usually send in an amendment or a correction. But it's really important to constantly look at the probate notes. Lawyers rely on those all the time.
Got it.
And not only does it take very long, heirs have to pay fees. So the probate fees, a lot of people don't understand this, but they're statutory. That means the legislature wrote a law that said what probate fees are. 4% so they're based on the value of the house, which is 4% of the first 100,000, 3% of the next 100,000, and 2% of every 100,000 thereafter. So that's if you have a high value, on your house, which of course in California we always have, higher values than other states, then that can be a lot of money. And then there's also filing fees of almost $500, appraiser fees, Don't think that you can just get a regular appraiser. You can't. It has to be one appointed by the court. And other court-related fees, and there may be a bond. Also, if the will, many wills provide for no bond, but if there's a bond set, then you're gonna have to pay 10% of that amount, which could be 50,000, could be, it could be any amount.
Oh, wow. That's a lot. So on $1 million estate, just to kind of round off, I'm a round numbers kind of guy. I like to keep it simple, but let's say you own a house, you have a retirement, you've got some assets, total $1 million. And John Doe passes away. I almost said, let's say I passed away. Probably. Knock on wood, folks, knock on wood. John Doe passes away with $1 million estate. Even if John Doe has $1 million house and owes $900,000 on it, he still pays the probate fees on the whole value of the house, correct?
Correct.
So on $1 million, what's that equate to as far as probate fees?
How do you, Joe? You figure that out because I became a lawyer, so you have to do that.
4% plus what?
4% of the first 100,000, 3% of the next 100,000, and 2% of every 100,000 thereafter.
4, 8 times.
See, you
8.
think
Oh man, don't worry, I got you. 16, it's about 20. Yeah, it's about. I think it's going to be. That's about $20,000 right there. That sound about right? Sounds about right.
And then there's all these other fees, like I said.
So you're going to be up in the $30,000 range, $40,000 range.
Yeah, and sometimes more depending on if there's problems or there's, things are unclear.
Oh, the court's going to get you. That's for sure.
Yeah.
Some additional questions on here. I think Paige sent a note that the probate court is calendaring for next year right now. And people should name their trust as their beneficiary. Yes, if you do have a trust, you should name the trust as the beneficiary. Typically,
I was gonna say, Joe. Just I know you have other questions, but typically,
hold them. Want to hold questions till the end?
No, you can do it. I like interaction, but I was just gonna say when she said they are calendaring for next year, most courts in any area of law right now are calendaring for the next year because
of post-COVID.
Yeah, everything got backed up, and then the clerks weren't even there. They left the court, like here in Whittier. They didn't come back to the court to actually work till I think it was like mid-August or something. So all those cases are getting filed and piling up. So.
Got it. Okay. Sandra wants to know the difference between administrator and executor.
Yeah, nothing.
Nothing. Same term. Daryl, what's the average cost for a trust in California? That depends on how much you own, how many assets you have, but what's a good range?
Yeah, I wanted to talk about that, but
we're going to go to that. If we're going to get to it, just tell me we'll get to it. It's fine.
No, I can answer it now.
Yeah?
Yes, I really want to caution people about using trust mills because... Trust
mill. That's funny. That's the part of Daryl's question I left out. He said LegalZoom, and I was like, yeah, we don't use LegalZoom.
Well,
Sorry,
first
Daryl.
thing is, if you want to be your own probate attorney, yes, use LegalZoom, but you're not going to understand necessarily all of the things that you need to understand.
I agree.
It's a law school. But the trust mills, like you'll see ads that'll say trust $3.99 or whatever. What I have found with working with a lot of clients and redoing their trust because they went to a trust mill is that a lot of the trust mills just have boilerplate language that may or may not apply to you. Okay, so first of all, I find there's a lot of extraneous language that apply to you, and then there's some language that is not even tailored to what your needs are or what your property is or what your assets are. So you get a whole bunch of boilerplate stuff that people think are impressive because it's a lot of pages, but it really doesn't mean anything.
Got it.
Many cases.
Okay, keep going. Probate process.
So the next slide is that since I just explained a little bit of the moral of the probate process, the moral of the story is your kids or your heirs are going to spend a lot of money, as Joe get out on the $1 million property to inherit.
Aldo figured that out. Mr. Aldo, thank you for the $23,000 math question answer there. Appreciate that, not including all of the extra stuff. So kudos to Mr. Aldo for the math.
Yes.
Good.
Thank you. So the next slide is the negatives, which we've kind of discussed. But the negatives are the court takes a long time. It's expensive. And your affairs public after death. You know, some people don't want their affairs to be public after death. And when I didn't answer what was a good amount for a trust. So I would caution away like the $399, $499, the $599, because often those trust mills do not do the deed work as well. And I like to work under trust. But I would say that we right now normally charge $2,500 if you have 1 or 2 properties. But right now we're doing a special $15. And it takes relatively a short time depending on how fast you can get us the information about what it is, what your assets are, and who the successor trustee is. And we'll get successor trustee in a minute. But
I will tell you my own personal story about my trust is $1,500 for a trust is well worth it. My own personal story is my family lives in New York. I've got a fiery Puerto Rican New York mother who I love her to death, but she is a spitfire. And so one of the motivators for me when I got my trust was to make sure I knew what was going to happen with my kids. Heaven forbid something happens to Joe and Kim. Mama Soto, my mama's going to be down here wanting to take those kids back to Brooklyn. And I don't want my kids going back to Brooklyn. So $1,500 will save you a lot of problems when you're gone and save your kids a lot of problems and your heirs. That's just my one little personal problem. But yeah, you lay all that out, which I'm sure we'll talk about some of that stuff.
yeah, once we get to trust. So I think,
So stories.
yeah, so I have a really actually intense story. So I have been a lawyer for a very, very, very long time. And at some point in 2005, I added probate to my areas of law. And so in the very beginning of adding probate to my area of law, I got a case where it was a will and it was real property, which again, I've already recommended that you don't do that. And I think that really we need to educate people about the difference between wills and trusts, and that makes a big difference. And also people that aren't that educated, they also need to know the difference in a very simple way about wills and trusts so that they know what their options are. Well, so I had this family, and first of all, it was a lost will. So people think, oh my gosh, a lost will, what do you do with a lost will? Well, you can lodge a copy of the will, and then you have to have some kind of evidentiary evidence that somebody saw the original will and can testify that this copy is a will. In fact, I have 2 cases right now where the person, the heir, was either not getting what they wanted or was cut out, and they ripped up the trust and ripped up the will. So, yeah, that little emotional outburst there. People get very emotional over wills and trusts.
No wonder why they got cut off the will. Gonna act
So
like
anyway,
that. Yeah, you're not gonna get nothing. You're gonna act like that.
no.
Jeez.
So we had this lost will. Then a lot of people in their will can provide for issue. If one of their children is dead, they can provide for those grandchildren, but a lot of them don't. So we had 5 siblings here, 4 were alive, 1 was dead. And it did not provide for the issue of the dead sibling. So the nephew decided to challenge the will anyway. So he did. Now, this is where you get into the drama and what Mr. Soto mentioned before. Just, it's a lot of family, a lot of family drama, a lot of family people are talking to each other. It's when money gets up there and gets into the middle of some kind of controversy, then it is a big thing. So he challenged the will, and all of the people decided to go to mediation. Now, this was at a time when we were in our economy where all of a sudden the houses began to not be the value as they were the value. So they agreed to pay the nephew a certain amount because they felt bad that their sibling was dead. But the value of the house then went down a little bit. And so they ended up actually getting less than the nephew did because it was a set price. But the story that I want to tell is that often they are, they go back to live in the family home. And my client, who was the executor, was living with his mother after he got out of the service. And we had told him for a year, year and a half, you have to get your own place. The will says the house has to be sold. The will says the house has to be sold. Well, we kept reminding him and reminding him. So the day before the house was going to be closing and that he had to turn over the keys to the new owners, he was still there. So the realtor and my paralegal called me in a panic and said, he's still there. What are we going to do? I had no idea what I was going to do, but I knew the keys had to be turned over on Monday. So Sunday afternoon, I went out to the property, knocked on the door at about 2 o'clock. He came out in his pajamas. And I said, today is the day you are moving. And today is the day you need to get out of this house because I'm not going to risk my bar license when I tell the court that we did not turn over the keys on Monday. So anyway, as the story goes on, I brought a friend with me who had a bat and of course, sort of undisclosed, because the brother had moved in, another sibling had moved into the house and holed himself up in this room, never came out. Because again, people don't talk to each other and his brother hadn't exactly told him everything that was going on with the estate. So we had a truck there to move his things. And what I know about people is people are curious. Curiosity kills the cat. So the brother was curious. As soon as the mover said, okay, we're taking the painting. Okay, we're taking the couch. Okay, we're taking the TV. Okay, is this okay to take? And on and on and on. The brother came out and he was a bit intimidating and was really Compton. And so I explained to him what was happening with the estate. And we had arranged for my client to stay at the month-long inn, the residence inn, because he had not found a place. And we had arranged for this stuff to go into storage. So we offered the brother the same thing. So I had to sit there painstakingly for hours while we got these people out, which they should have been. And the realtor, had tried and tried and tried, but hadn't gotten them out. So the end of the story was, I said I needed the keys. Poor man started crying. He was very, emotional about his mother's death. And it took a little bit of time on the porch to get the keys. But those are like really great stories lawyers like to tell, but they're kind of sad stories as well because people don't understand the probate court process. So we did move the brother out. We did move the brother to the residence inn. And I was able to say to the court and the judge that we were able to turn over the keys on that Monday morning.
Oh, wow. That's crazy.
So I want to say what they tell us, and I'm sure they tell you all who are listening. What they tell us at the State Bar Convention is there's two things that get you ahead of life. One is your people skills, and one is your ability to deal with conflict.
Lots of conflict. But shouldn't that person, Paige brings up a good point, but wouldn't that person have been given a notice to get out of the house? Or how did that work back then?
Of course they would have been given notice, but when in being an attorney for as long as I've been, I notice a lot of people don't read, and they get court notices or they get foreclosure notices, and they hide them under the couch or wherever.
Oh, gotcha.
And they don't read them.
Convenient. Got it. Okay.
So we should go on now to the next slide, which tells us.
What is trust?
Trust. So a trust is also a legal document, and it holds real property for the benefit of their heirs or beneficiaries as the same thing, but it's the only way to avoid probate.
Oh.
So my next slide shows a little bit of sort of some of the benefits, and we'll talk about them at the end, but a trust gives them complete control over all the assets while you're alive. So you see up there, it's a little spotty, it says it avoids the court.
Avoid the court process, probate process.
Right. And most of the people that we do trust for have a revocable trust because you want to be able to change the trust, especially if you get the trust, and have it for a number of years. You want to have a revocable living trust. And that just means that you're able to change it. And people often ask me, is it hard to change a trust? Is it hard to change a trust? But you just have amendments. So if one of your children die, which is a very sad thing, but I've had lots of clients where multiple children have died, and they have to change the trust. It's an easy fix. You just do the First Amendment or the Second Amendment or whatever amendment, it is.
Sometimes the kids change, right? Or the heirs change. You decide, like, my daughter married the wrong person. I don't want to leave her anything. I can change that, right?
Yep. That's why you want a revocable living trust. You don't want an irrevocable living trust. Irrevocable, you can't change it. And don't do any of those. I forget what the next slide is, but let's do a simple trust. So usually a husband and wife, and when one dies, we recommend that the other party, whether it be the wife or the husband, become the successor trustee. And then when both die, another successor trustee comes in, like a son, a daughter, a relative, a close friend. Mm-hmm. At Bailey and Romero, which is our new partnership, we prepare not only the trust, the living trust, but we do the pour over will, which Mr. Soto mentioned before, because the will just pours over everything into the trust. We do the power of attorney for the financial, the power of attorney for the medical, the HIPAA, which is the Health Insurance and Accountability Act, because usually what happens is when the mom or dad die, the heirs are usually are adults by this time. And when you're both adults, it's illegal to give medical information to another adult if you don't have consent. So that was enacted as a federal law to sort of make all the states have a separate standard, the same standard to protect medical information. Being discovered, being handed to and disclosed to another person without the patient's consent. So if your mom or dad could be in the hospital and they can't give you any information because you don't have a HIPAA. Then we also do the living will, which living wills are, most people don't want to be on, ventilators or tubes for the rest of their lives.
Yeah.
But what I want to tell people, they're all like, oh, I have to make that decision. And I'm like, well, if you're doing it with the doctor is going to say, we recommend, they're on for this long, or they're not on, or there's no way they're going to recover, or whatever it is. You're not making it without the medical, help and input from their doctor and their specialists, especially if they're in a dire medical condition. And then the other thing that we do, so we do all of those documents as well as the deed work. So the deed is, the trust has to be what we call, it has to be funded. So the deed, which is a trust transfer deed, will transfer the real property into the trust. And it's just basically, your deed as husband and wife now as trustees of the whatever, Romero Family Trust, or whatever it is. But if you never transfer the property by a trust transfer deed, then it's not funded, it's void. Now, many of those trust mills that I talked about earlier, they don't even touch the deed work. So you have a trust that you paid for, maybe you paid $3.99, $5.99, $7.99, but no deed work was done, so it's literally void. So that money was not really a good investment because you don't really have a trust. It's not funded.
So that was a question earlier from Laura, who asked if a person can do their own trust, right? And I think that's kind of what you're referring to, is those trust mills or LegalZoom or these companies that have you do the legal paperwork on your own. Obviously, can a person write their own trust? I don't know if that's, can a person just write their own? I don't think they can. They have to be a lawyer to write a trust, right, Martha?
Again, there are several elements that need to be in that trust. So whether everybody knows everything, even if you're going through legal Zoom. I sat next to somebody in the chamber, and she said she did the whole legal Zoom thing, but she didn't have any idea what the hell she was doing. So she wanted to know if I could do the trust for her parents, because she said, I went through this whole thing and they asked this, but I didn't really know what they were asking, and I just figured it out.
Yeah, I think that's one of the biggest things that you mentioned was, to answer Laura's question was, you could do a legal Zoom, right? But the most important piece of the puzzle is funding the trust, right? Making sure that your house is in the trust, making sure your bank accounts are in the trust, making sure your assets are in the trust, making sure that everything is in the name of the trust. And a lot of times I don't know, I've never used any of those companies, but a lot of times they will say, okay, now your next step is to go to a title company and figure out how to put the house in a trust. And you don't want to mess that up. That would be a big boo-boo. So, probably I wouldn't recommend it personally, but everybody different strokes for different folks.
Yeah, I'm with you. I wouldn't recommend it at all, because you have to have certain things in there. And even though you might be going through a checklist, you not really know what you're writing. You're writing legal language, and most people are not that familiar.
Yeah. Good point by Yvonne. Said spend the money and get it done right the first time. I agree with you, Ms. Yvonne. Thank you. Daryl had another quick question. Does marriage supersede an active trust agreement? What if the married couple does not agree with the beneficiary named in the trust? So if somebody's married, so if I'm married, if I have a trust and then I get married, Daryl, I'm not sure on how that's worded. Does the marriage change the trust? I don't know how that affects.
It sounds like they need counseling so that they can go and get somebody.
There you go, Daryl. If there's a trust, I don't think if you get married, it doesn't change the trust, right? So if you and I hope this answered your question, Daryl, and if it doesn't, you can comment. But if you're, if I have a trust and let's say I get remarried, my trust is still in place. I would have to change the trust to put my new wife as a beneficiary or add her to that trust. Same thing if my kids get married, my kids are still beneficiaries. Their spouses, right, are entitled because they're married now, I guess, or something like that. I mean, that's a whole nother thing, or how does that work?
We're going to talk about that if we could move on to the next slide. Talk about children and spouses. So I think we talked who is a successor trustee, and most of my clients make the same person the successor trustee. So they carry out the order, what says in the trust, and they can't just say, oh, I don't think that was a good thing, I'm going to just do whatever, which some people do. And that's not a good thing. They have to carry out the terms of the trust. They are now a fiduciary, meaning they have a special relationship to that estate. And they are fiduciary, and they have to carry out everything to the T on that trust. So usually the successor trustee that they name, okay, which I said before is often the husband or wife initially, because they're both not going to be, hopefully expire at the same time. So, so they carry out everything from the trust, and then if the mom and dad, the example that I gave, are both dead, then like I said, it's usually a child
name somebody else
or relative or close friend, and they are fiduciary to the estate as well. Now it's important to have more than one successor trustee, because obviously if you name the spouse, that spouse is eventually going to pass. And then so you need to have another successor trustee and then a backup to that, because you just never know what's going to happen. If they don't want to serve, or if they happen to die prior to the death of both of the parties, then you need to have a backup successor trustee.
Gotcha.
And then, yeah. So you could go to the next slide, I think.
Trust administration?
Yes, so when both of the trustees are dead, trustors are dead, many people do not know this, but you need to hire a lawyer, and this is why. There are certain provisions under the probate code where notice has to be given out to all the heirs. People don't know how to do that. So, we charge a very, very nominal fee unless there's extraordinary things that we have to do. But the person who's in charge, whether it be the granddaughter, the daughter, the friend, they don't know how to carry out the trust necessarily, because certain type of records need to be maintained, notice has to be given, and then there's certain things that have to be done to protect the Proposition 13 that protects the property taxes if the family is going to keep the house or the property. There are certain things that have to be done with the assessor. Now, a lot of people call the assessor the tax assessor. So I'm a former deputy county counsel, which means that I was the attorney to the county administrator. And one of my clients was the treasurer and tax collector. One of my clients was the assessor. So the assessor values the asset, the home, the property, and then the tax collector just administers it, whatever the value is. So they're two separate, entirely departments, and so they should not be mixed up and called the tax assessor, the assessor and the tax collector. But many people do not know that you have to lodge the trust with the assessor within 50 days and go onto their website and download numerous documents to protect that Proposition 13 if the heirs are keeping the house. So it's a notice of death, it's the property, the trust, so that the assessor can verify that that's going to whoever, the child or the grandchild or whatever. Now, we know right now that Prop 15 is being challenged. I don't want to get political, but Prop 15 is being challenged. I mean, Prop 13 is being challenged by Prop 15 on the ballot. So we all want to look at that closely. Prop 19 is also being challenged. That is when Proposition 58 was passed that allowed grandparents to transfer to grandchildren, children, and parent-child exemption. That means that they would still have the Proposition 13 tax benefit, and they're trying to get rid of that under Prop 19.
Gotcha. That's a whole other rabbit hole, though. We don't want to. That's another
right.
2-hour class. We don't want to go in there. Yeah, we don't want to go down that road.
No, I don't want to be political. Just wanted to
make sure we know.
Yeah. So the what's the next slide? Let's see.
Benefits.
Okay. So here are the benefits. Avoids costly and lengthy probate, which we already talked about. If there's medical liens, we have to look at those, and they can possibly be avoided, like Medi-Cal. Next slide. Protects in case of disagreements, because you've laid out everything. See, in a will, anybody can challenge that will. Okay, next.
Gotcha. And I think there was a question in here. Somebody had a question about trust being the same as a DNR, like a do not resuscitate. I don't know what the difference. I don't know, like.
That would be the same, a little bit maybe different language, but the same concept between the living will.
Gotcha. Yeah, and so I think. Like on the trust, you can definitely outline that if something were to happen to you, what you want done. With different documents, that would be in the healthcare directive. Is that right?
That would be a living will.
Living will. But that's part of the trust, no?
Yes, that's part of the trust. All those documents that I named are part of the trust.
Gotcha.
So next. Okay, so I have a sad story, but my own aunt and uncle, they did a living trust, but they went to a trust mill because my uncle was always for the bargain, right? So before he died, my aunt, who was my mother's sister, and my uncle, who was my dad's brother, his brother's sister married to brother's sister, she came to me, she said, could you look at this trust? Because we just want to make sure. And I looked at it, and trust mills often do not explain anything that you're signing.
Oh, it looks like we're losing our connection there.
During you to sign it.
There. Say that again, Martha.
I said that
the trust mills don't explain.
Often don't explain the documents. So what they did was they were signing everything in sign here, sign here, sign here. They actually signed and revoked their living trust on the day that they had it made because nobody explained to them that form was for later. Like if they wanted to totally revoke it or change it, You sign here. Well, they signed it on the day they did the will and trust. And I had to tell my auntie that you not only made the trust on the same day, you revoked it on the same day. So you've not had a trust all this time.
Oh, wow. That's crazy. They let them do that? Like,
Well, they're not explaining it to them, and people could read, but they don't maybe understand what they're reading, number one, and they don't, understand the consequences.
wow. That's insane. Adding children to title.
This is a controversial topic
This is a good one.
because a lot of people want to add their child to title. And we know.
I just had a client want to add his 11-year-old to title, by the way.
Oh, well, she can't be added because she's not 18.
Yeah.
And enter into.
He's like, let's put
Anyway.
my 11-year-old on. Okay.
Adding the child to title is not a good idea, and at Bailey and Romero, we don't recommend it because one of the things that happens when a child inherits is the basis of the property, and this all has to do with taxation. So if there's a property that's worth $400,000 and you add your child to title, and then when you die, it's $800,000, the basis they get is $400,000 because the child didn't inherit it at $800,000. So $800,000, if they had inherited, would be the basis. And then I don't know what the tax ramifications would be on a $400,000 gain because it would depend on their own personal financial things. Now, when I did my cousin, one of my older cousins, my dad's cousin, they had added a bunch of children to title, not all of them. So we took them all off, and then we just had, my cousin and her husband, and then we went from there, but we took them all off.
Gotcha. So I think what Martha is trying to say is we get clients sometimes where mom has owned the house for 50 years. She doesn't have a will or a trust, but she goes, I'm just going to put my daughter on the title. And then if I die, my daughter will take it. Right, Martha?
Right, but the other really, really, really horrible thing about this is that the children are adult children, so they can get into trouble. So if they get into trouble and a judgment's entered against them, the creditor could actually execute against that real property by filing a lien as to their interest, as the interest of the child. Let's say 50. Let's say it's 50-50. Or another lady who I wanted to help, but she was so overwhelmed she didn't retain us. Her mother was fighting with her. They each owned 50-50, and her mother wanted to sell the property and, file a partition action against her, which means, she wants to sell it, she'll get her 50, the child will get 50. And the adult child didn't want to do that. And the mother was having a little bit of dementia issues, so she was being very influenced by another child. So there's problems with adding children to title, but you don't want your family home have a lien against it because your child either did a criminal act, a civil act, or didn't pay their bills or whatever. Not that lien against your property.
Yeah, I've seen that a number of times where people put family members on title, and I'm like, yeah, you definitely don't want to do that. And it's just one of those things where people don't know the ramifications, right? They think that they're protecting themselves, but it could open up a whole nother can of worms. So. Good. So you can't put an 11-year-old on title? No, I'm just kidding. Just kidding. Joint tenancy versus community property.
And this is a huge controversial topic because
Why?
what we learned in law school was that most realtors and most lenders and whatever were touting joint tenancy because that means that it automatically, the interest of the person that's dead automatically goes to the other party. And usually when it's a husband and wife, it's 50-50, so it automatically. Now, our state, I'm going to give you a little background. Our state is a community property state with our westward ho and our newfound openness about different laws. There are only 7 community property states. California is one of them, Arizona, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. And I didn't know this, so I looked it up, but Alaska is the opt-in state. You can have community property or not have community property.
Interesting.
Anyway, I'm going to give you a scenario. So let's say that.
This was actually, hold on, this was actually a question from
Okay.
someone where she asked, in a community property state like California, can someone exclude their spouse from the estate? So if you could answer that as you're going on, sorry to cut you off.
That's okay. So this might answer her question by this little example. So
Yeah.
if you are married and you're community property means everything is community property, okay?
50-50.
50-50. Now, there is a way to, if you own property, let's say prior to marriage, if the vesting on the deed is correct. And I notice a lot of title companies and a lot of deeds don't have vesting on it. A lot of court actions are ended up because there's no vesting. So if the vesting on the deed says something like Martha Romero, a single woman, as her sole and separate property, that language as her sole and separate property is very important. A lot of deeds don't have the vesting that I have found. Okay, so now let's say I get married. At the time that I owned that property, I was still a single woman. It was my sole and separate. Now, could I put my husband's name on the property? I could, but I might not want to because maybe I've owned this property for a while. Maybe it's a family property. Maybe I just don't want to. Okay, I just want to keep my separate property. But anyway, what I was going to say, let's say you're married and then your husband or wife dies. So let's just say the wife dies, okay? And let's say the wife you had minor children, or the wife had adult children from a prior relationship. Then let's say the husband remarries and the husband puts the new wife on the property. So what happens is then the wife's children or the minor children they had together or the adult children get totally wiped out of any type of inheritance. Whereas if you put it in community property as husbands and wives, under the trust, you could give 50% of your estate to your children or children from prior relationships. We all have these blended families right now. Now, if it's community property and you have title in both names, husband and wife, you really can't exclude. You can take your 50%, but you can't exclude a spouse. You can exclude a spouse on property only if it's your sole and separate property. Now, let's say you have an agreement during your marriage and you want to buy a piece of property. The wife wants to buy a piece of property. You can put it as sole and separate property if the husband signs off on that. They have to sign off because everything in the state of California is presumed to be community property unless the correct vesting is done or when during the marriage your husband would sign off his community property interest in that example I just gave.
So if I have a house, I get married. I've owned a house for 10 years. I get married. Spouse automatically gets 50% because I walk down the aisle.
No, if the vesting says
Single man,
single man is your sole and separate property, the only way it would become community property is if you add her to the deed.
Gotcha.
And some people that are older when they get married or younger, doesn't matter, might want to do a prenuptial agreement to specifically say, this property was owned during marriage, or maybe this business was owned prior to marriage, so it's my family business, I'm going to keep it a separate. But you have to specifically delineate that it's separate property, especially in California, because we are a community property state.
So with a trust, I have a house with my ex-wife. I get remarried. I can put that house in the trust and say, new wife, you have no ownership in this house. This house, if I die, goes to my kids.
Well, if it was vested as...
Let's say it was vested with my old wife, previous wife, right? Or by myself.
Right.
New wife is not on the house at all. New wife hasn't been on the house at all.
Right, but you probably want to change that vesting because, it's likely that in your divorce that, something is going to have changed. So you want to just protect your title. So if you've protected your title and you still own 50% of that property, yes, you can specifically name that property and give it to your children.
Gotcha. Okay. So I think what's really interesting about this is that there's so many moving parts, right? Like I love the questions, and I'm grateful for everybody chiming in on questions. But as you can see, there's lots of moving parts, and so the benefit of having a Martha in your corner is priceless, because there's just so much that can go wrong, right? And it's better to be proactive instead of reactive, and all of a sudden you find out you can't do that, and you spouse is entitled to 50% of the house, and you're going, oh man, that's not good. So,
but I want to, if there's any title companies on here or people that work with title companies, it's really important to have vesting. So I've often seen, Joe, like, you and your ex-wife, as, two parties and then no vesting. I mean, constant, I see a lot of no vesting.
Yeah.
Before I want to thank you for this opportunity, I also wanted to answer more questions, but I wanted to give you a little bit more detail of the probate process, a little bit, because I know that many realtors deal with probates, and it's always important to be very savvy and have done some probates, because many times you have to be able to testify in a court of law. And many realtors have not had that, have not had to do that, or, they've never had a property where that ever came up. So it's really important. I know from my contacts with realtors that they have, there's classes for you to take. And I think it's really important that you need to be savvy and to be really honest about if you are, going to assist an attorney, that you be really honest about how many probates you have done, whether they were simple or complex, and whether or not you've ever testified in a court of law. Because it can be very undaunting to testify if you've never done that. Not to say that you can't do that or we can't prep you, but I'm just saying it's a whole new thing, sort of outside, not something that you normally do every day. So I wanted to talk a little bit more about the the probate process a little bit, unless there's some more questions you want me to answer first.
I have a couple. I think I know the answer to this one, but question: realtor, client sold a home that was in a trust and received the funds, $500,000, let's say, profit from the made out to the trust, but the attorney had not opened a trust account. So the issue is, if you're getting funds in the name of the trust, your bank account also has to have the name of the trust, right? Like for me in Soto Family Trust, if the money's getting paid out to the trust, the money has to go to a bank account with the trust. Do you know that answer, Martha?
It does.
Well, usually when somebody becomes a successor trustee, like I have an example right now. I have a client that her father had Alzheimer's and was just worsening and worsening and worsening. So she had to sell a family home, and he's in a assisted living right now. And she had to open a different bank account to cover, it's closing like in a couple of days. So she's going to put that money in there. She's also going to put money perhaps of her own in there, because she had to pay for certain things that she's not going to get reimbursed until she gets those funds.
Got it.
And so you want to keep that separate. You definitely do not
keep it separate,
because any heir can challenge you on anything. And that's what I was going to say. Even with trust, we think maybe there's no litigation because you don't go to court, but anyone could challenge the successor trustee and say, you're not doing this, you're not doing that. And so I have a case where there were 9 children, 3 died prior to the mother dying, and she had appointed a successor trustee. But this was the oldest son, got very, very depressed and sort of isolated himself over the death of her mother, and did not do anything, didn't do the thing within the 50 days with the assessor, didn't pay the property tax, and just shut down. So the oldest daughter, brought a petition to remove him as a successor trustee, and just states, okay, he didn't do this, he didn't do that, whatever it is, that they're not doing. And, so I'm not going to say there's never any trust litigation, because there are, again, if you don't hire an attorney to help you with that trust administration, you too
You could be in trouble.
yeah, you could be in trouble, big trouble.
Okay. Beatrice had a question. I think she may have to reach out to you for it, but family's been living in a home where the parents passed away 5 years ago. What happens if they want to sell? Assuming, Beatrice, that they don't have a trust. Do you, I don't know if you want to give me any more information on that, but if somebody passes away and the family has been living in the house, paying the mortgage, if they want to do something at that point, if there's no trust, it's got to go to probate, right? Even if it was 5 years ago, 10 years ago, whatever it is.
That's correct. And we find that sometime, one time we did the 3-generation probate because the great-grandfather, didn't do anything. The grandfather didn't do nothing. The son didn't do anything. So we had to open 3 probates simultaneously, even if it's been a number of years. Because
Wow.
all know you can't sell a property with a dead person's name on it.
Correct. That's a good question, Ms. Beatrice. You probably want to reach out to Martha on that because they're going to have lots of questions if they want to sell that house. Can you exclude, we talked about that one. Vesting is changed when you form a trust, right? So can vesting be changed when you form a trust? I have a trust. I have a house right now in my own name and I do a trust. That's what you were talking about, Martha, right? Where the attorney would prepare the deeds and do the vesting for you at that point. Is that right?
Right, but we would have to look at the current deed. So in one of the cases I have, she never took her ex-husband off the trust, off the deed when he died 20 years ago. So we had to go in and do that deed work first. So that was a joint tenant situation. So you do an affidavit for joint tenant, you take him off. Then we can do the transfer because you don't want to cloud title. Do all these weird things.
Oh yeah.
Trust, yeah.
Lots of moving pieces. If 2 people are in a committed relationship but not legally married, can they take title as community property?
They can take title as tenants in common, but not as community property because they're not married. But there'll be tenants in common, and they could lay out if they want it to be 50-50. They could lay that out.
Gotcha.
They would not
community property.
Community property, husband and wife. They'd be co-tenants.
Got it.
I just say I had a case from a realtor that sent over that the people were totally freaked out because 3 people were on title: the uncle and then the husband and wife. So the uncle died, and they tried to talk to the bank about it, but the loan was only in the uncle's name, so the bank refused to talk to them. So they were all freaked out because when they first called me, they didn't give me all the facts, and I don't like not getting all the facts because we need all the facts. But
you need all the facts.
Right. I thought they may need a probate, but I said, you know what? Before I go any further, I need to see the documents. So once they sent me over the deed, it was a simple just removing the uncle because it was a tenancy, and then
maybe we want to do it like that. EDD.
That took a
tax
while.
And licenses.
I have to say, as well as COVID has affected the courts, this has affected the registrar recorder as well.
EDD.
So it has taken months. I have a service where I get a confirmation of the filing within a few days, but the original document, like I've been waiting one for about 4 months now, for the original document to come back. So they're really backed up there now, and I hear now it's only e-filing. So before it used to be able to go in, and you can't do that anymore. Or if you used a service, they could personally go in, but now it's all e-filing. So then that's another hurdle.
Gotcha.
So
that's a good point on the joint tenancy, because the joint tenancy basically just, I have joint tenancy with you. If I pass away, the ownership 100% goes to you, right?
Right, but as we explained with the community property issue, you may not want 100%, 50% or whatever interest it is to go to the other person, 100, so that they own it and see 100%.
That's the answer to Simona's question on there. She kind of asked about joint tenancy, and she got more questions on that. So let's go. I think we've got about 15 minutes. If you want to cover some more of the probate stuff, we can go over that because I think that's really valuable for the agents on here.
Yeah, I think I want to get to the part where the agents might be involved. So
Yeah.
when you submit a petition to be a administrator, executor, executrix, they're all the same thing, or the personal representative, you know, they all mean the same thing, and I don't know why they just don't standardize the terms, because then we get the question, oh, is an executive the same as a personal representative? Okay, so once they get the authority, it can be limited or it can be full. Now, we usually like to get full authority, but of course it depends on what's, you know, in the will, or if it's not in the will, the court might not give full authority. That's because if there's no bond posted, and depending on who the proposed executor or executrix is, the court may think, you know, you're gonna abscond with the money, or, you know, sell the house, take the money, whatever. So that's why sometimes they require bonds. The reason we like to get full authority, because then the court oversight, which we explained what the probate process was, is not looking over every single thing you're doing. Okay, so you can sell the house with full authority. You don't need to go back to the court and say, oh, I need permission. But if you have limited authority, you do have to go back. And that you see, if any of the realtors have seen auctions in the court, they'll say, you know, we're now selling, you know, this property. We see there's 3 bidders here. Or where you get the limited authority, where you file what's called a notice to sell, and then you list the property you want to sell, and then the court can grant that. Usually the court will grant that. And then you get, you know, you get the realtor. But where the realtor might have to testify is, let's say it takes a long time to be selling, okay? Because right now it doesn't, but, you know, in other times, in other scenarios, it has. Or let's say there's some problems with the property, you know, with some kind of mold or something. There's just something wrong. We may need to file as the attorney a declaration with the court saying it hasn't sold because of these reasons, or there's these issues. And then often the court might want to hear it right out of the realtor's mouth. So then, you know, you have to get dressed up with court appropriate and go down to the court and testify. But the lawyer, you know, obviously helps you and tells you what you need to focus on. I've only had one case in all of the years that I've been doing probate where that had to happen. And I've only seen a few where they're actually doing it from the court as a bid because nobody bought it on the open market. So, but it can, you know, it can happen. And especially in those times when we are in a recession, which I know that we're not right now, but we may be shortly, that can happen because houses are underwater, and, you know, it's harder, you know, it's just harder to obviously sell those. Yeah, move those on. But a probate, if it's a simple probate, meaning that there's a will, it pretty much defines what the, you know, what is going to happen with the property. And again, I want to say we don't recommend you use a will for real property because you don't want to be in court. But let's say that's what you have, and it's pretty direct. And then it's basically just going through the actions, and it usually can close within a year or so. Because you're going to get your letters within 60 to 90 days. With COVID, I'm not sure now, but it could be a little bit longer. And then you have to do the various actions that you have to do to carry out the will, you know, which is maybe the selling of real property, the distribution of assets, those sorts of things. Now with the trust, I want, so that's basically what happens. And at the end of let me go back to the will for a second, there has to be an accounting file. That's why I said whoever is the executor, the executrix, or the administrator has to keep, you know, it doesn't have to be a
records of what's spent.
Yes, of what's spent. It doesn't necessarily have to be an Excel sheet, but, you know, people can just keep an Excel sheet, but they can also just keep a handwritten ledger, whatever it is that they're comfortable. It has to have everything. And if you need to be reimbursed for things, like in the story I told you where the successor trustee, who's the oldest daughter, had to put the father into the home, and she's getting reimbursed for a lot of things that, you know, that she's going to, had to do with the property, then you have to keep receipts. You know, it's great to keep monthly receipts, what they're for, document them, keep a, you know, Excel sheet or a ledger if you can, because all of that is going to be really important when the estate is closed, because you have to file a formal accounting, which most people do not know how to file that type of accounting. It's just not a regular accounting. with the
Yeah.
court. There's special rules, special things that have to happen. And that's the closure of the probate estate. Usually it can be done in a year. We never like to say that. We can say up to a year unless there's other, complicating problems. So
But right now with COVID, it's probably even longer than a year. I mean, way longer, you
it
know.
could be. It could be. I'll find out when I file this I'm going to be filing a probate, an actual probate, and we'll see what they say. But that's why it's always really, really, really good to do everything perfect, because then you don't want to appear at court. You want to do, you want to get that.
Don't avoid court.
Yeah, recommended for approval. And another thing I want to really, it's education, but I have a case right now where the attorney, remember I went back to the statutory fees, the 4%, whatever, and we figured out how much that was.
Uh-huh.
Never go to a probate lawyer where they say that'll be an hourly rate. That's against our professional rules of ethics. It's against our professional conduct. And they can, I have a case like that right now with the attorney charged an hourly rate. You cannot do that. Okay, it has to be by the statutory. That's why you can get a little bit money up for costs, like the filing fee and the appraiser and things like that. But the fee, the statutory fee is at the end, at the very end that the whole case is over. That's why
That's where it's paid.
Yeah, doesn't want to go into that area because it could take a long time for you to get the statutory fee.
Gotcha. Let's wrap up with a couple of questions. Daryl had a good one. So you're married, you buy a property with a separate account. So Joe Soto has got his own bank account, but from my wife. Are you not allowed to do sole ownership due to community property laws? Does this require, so I'm married, but my spouse is not on the loan or on the property, I'm buying it with my own money.
Well, so there's a bunch of questions in there, as only a lawyer would know. Number one, is it really because once you get married, unless you totally keep that account separate and you designate that as a total separate account, anything that's, that will be considered community property, even if only your name is on it. So you have to be careful. Again, nothing can be commingled out of that account. You have to understanding that's your sole account. But yes, of course, I talked about that. Yes, of course, things can be separate. That's not the intent of the state of California. That's why everything is presumed to be community property. But again,
the spouse has to sign something off of that house, right?
So yes, if he does the correct vesting, like we talked about, sole and separate property, and the spouse signs off, then, so it's a number of steps,
Spouse has to sign an interspousal deed
Yes.
or a quitclaim deed?
Yes.
Interspousal.
Yeah.
That's a big question that I get where people say, well, they just signed a quitclaim deed. Quitclaim deed takes the person off of title, but does not take away their ownership interest, right? So I make my wife, using an example, I make my wife sign a quitclaim deed for our house. But she still has 50-50 unless she signs an interspousal deed. Then she's saying, interspousal deed says, this is just your house, Joe Soto. Is that right?
No,
something like that?
Well, a quitclaim deed, that too. But again, we have to be very careful about the who's on there and then the vesting. Because a quitclaim deed, remember, is just a deed that transfers whatever interest that you have to whoever you're going to transfer that to. So that possibly could be done, but when it's an escrow, they usually make you sign an interspousal.
Gotcha. Okay. And then last question from Yvonne. Why would anybody do a will in this day and age over a trust?
Well, people are uneducated, and I'm a third generation Latina that my father was absolutely dedicated to educating us. I have two brothers, so we all, went to college and wanted to be a lawyer, so that luckily those doors were opened. And you would just have to be educated, and a lot of our population.
Parents, grandparents, they don't know.
Yeah, they're not educated. They're not educated about it. So nobody would want to do a will who owns real estate, okay, than a trust. And then a lot of people, I think this is a little bit, we have to kind of step back and look at, they say, $1,500, well, that's a lot of money. Okay, well, here at Bailey and Romero, we work with you, we'll take payments, but if you explain to them it's $1,500 versus 23,000 or 40,000 or 50,000 or whatever it ends up to be, then they get a little bit more perspective, but they just don't know. Think 1,500 or 2,000 or whatever it is that you're going to be paying is a whole lot of money, but it isn't in the big picture of life.
That's true. So I had a client. I'll end with a little story, and I will put Martha's information in the chat as well. But I had a client. I did a loan for the parents. Parents were in their 90s or 80s. They were in the 80s. Dad gets sick. Mom's the only one left on the house. I tell my client, you need to get a trust. No, I'm good. We're fine. My sister's handling it. You need a trust. Did you get a trust for mom? No, I didn't get a trust for mom. Mom gets cancer. I'm like, you need to get a trust. Can you please, look, here's 10 attorney numbers within your area, like 5-minute drive. Get a trust. My sister's handling it. It's fine. January of last year, mom passed away. January of last year, January of this year? January of last year. Mom passed away. And guess what she did right before she passed away? She deeded the house to the sister by herself. No siblings, just her. So what you said about the step up in basis, they lose that, right? Is the one thing. But it turned out mom passed away, and sister saying, yeah, she didn't want any of you to have any of this house.
Wow.
It's worth about $1.6 million. And sister's like, no. She signed it all over to me. She wanted me to have it. So sorry, everybody. Sister kept the house.
Wow.
Joe, we have to be careful too about, I don't know about that situation, but there's other situations where there's greedy children and they often forge. When parents get sick, sometimes they just put a paper in front of them and say, sign this. This is a letter to so-and-so or whatever.
100%.
It's a lot of undue influence, or they were not even lucid. So there's a lot of that goes on. Not saying that any of your clients are going to do that, but I've seen a lot of children do that, and that has to all be unraveled.
Oh, for sure. And I think that's the biggest thing, is just to protect everybody, right? As you can see by just this short amount of time, that there's lots of moving pieces, right? And so I urge you to reach out to Martha. I put her information in this chat. If you have additional questions, it's really important to sit down and talk. Take your parents or your clients to speak to someone and to take the right precautions, because it gets really ugly when somebody passes away. Money brings out the worst in people. It really, really does more often than not. So it's better to be safe than sorry.
It does, and I wanted to just tell you all that on our Facebook page, there are a couple of videos, especially a rather longer video that explains more about the probate process. And we also do other areas of law, and this isn't relating to probates and trusts, but I know that the governor passed AB 330 on August 31st that outlines all the new regulations for landlords and tenants, and so we're totally have that down too, and you can see the other things that we do. But I really, really want to thank you for your attention. I hope that I explained it in a very simplistic way, even though the matters might be complex. And I really wanted to thank Joe again for having me on.
Absolutely. I appreciate everybody's time. This is recorded, so we'll make sure that we get PWR to send it out. And if you have any questions, you can reach out to Martha. You can reach out to me, Joe at Joe Soto Team, or 866-JOE-SOTO. Easiest number in the world, 866-JOE-SOTO. I don't know anything about trust, but I know a lot about loans. And that's it. I appreciate everybody's time today. I will leave the chat up for a little bit. That way you can get the phone number. I see that it's in there. Martha, do you have an email address?
I was going to just put that in there. I was thinking, so I'm going to put that in there.
I would say we'll put her phone and email in the chat, and then if you just reference the class at PWR or class follow-up, that way she knows. That would be super awesome if you've got questions or anything like that. But yeah, definitely the most important information. People spend their life trying to get a house, and then unforeseen happens. So, there you go.
And not to be political, but educate people about those propositions too, because they've been trying to attack those types of past. Proposition 13 has been in our state since 1978. We're the only state out of all the states that have Prop 13.
And I think I just redid the phone and the email. I think I may have done it differently.
Okay.
So let's see if I did it right. All panelists, everybody should have it on there. Martha's phone number is 562-324-6067, 562-364-6267.
No,
And the email is
324.
324-6067. 562-324-6067. Or marthaeromerolaw@gmail.com.
Or you can always look me up in the state bar. You know, if you ever gone to the state bar of California, you put in attorney search, and there I am.
Boom. She's on Facebook too, apparently. Instagram.
Yeah.
I don't know. Find her on there too. So good stuff. Let me check the Q&A for us. Can personal property be in a trust, Ms. Martha?
Yes, and personal, and if you have specific bequeaths, like you want to give those pearls to your granddaughter or whatever, that can all be included in the trust.
Okay. Good question. How is personal properties? Yeah, personal properties would be transferred through the trust.
It can be, yes.
I want to leave my kid my baseball card collection. That sort of stuff.
Yes.
Just kidding.
But hopefully the person that you've selected as the successor trustee is going to know all of that, you know.
Never assume. You never assume. Be like, I want little Johnny to have my Mickey Mantle baseball card.
That can be in there.
I got 1 minute. Any final part? Any final questions? Doesn't transfer the trust. Oh, that might be a tax question for you, Mr. Chad. But father dies. I'll give it to you anyway. Father died 20 years ago, but the son didn't transfer from the trust, dad's trust, to the son's name. Is the son going to lose the step-up basis? So you have to do that within a certain amount of time. 2 years is what Mr. Chad is asking. But 20 years ago, dad passed away. Nothing was done to transfer title. You have any idea about that step-up in basis, or is that a tax question?
No, then we'd have to see the trust. We'd have to see what the provisions are, and then we would have to do the deed work. Like I said, we did a multi-generational thing one time. We had to open 3 row probates open at the same time.
But is there a break on the step-up in basis? Like, is there a certain time frame, or would it go back to the value 20 years ago?
It would go back to the value 20 years ago, because I didn't get to say this because you reminded me right now. Everybody should have an appraisal at the date of death. So it's usually when the second mom or pop dies, you have an appraisal done, so you know the date of death value.
Gotcha. Good point. Cool. Well, I put everybody's information in there. I appreciate everybody's time and for spending a morning with us. And if you have any questions, reach out to any of us, and hopefully we'll get this recording out to everybody. So thank you all. Thank you, Ms. Martha. Appreciate it.
Okay.
All right. Bye.
Bye.